Hello, everybody. Thanks for joining. It's the last Wednesday of October, so it's time again for a fireside chat of Swiss patent litigation matters. I skipped the last session actually because not that much had happened the last 2 months, but that definitely does not hold true anymore for October. So quite a lot of things have happened, not only at the Federal Patent Court, but also at the EPO and in Swiss legal matters, meaning draft bills for a change to the Patent Act and so forth. So a lot of things to talk about today. So let's dive right in with these things that I have on my agenda. I shared the agenda on LinkedIn and via email. So I will pretty much stick to that agenda with one minor addition in the end. Now that I mentioned the comments on LinkedIn, if you have any questions during the talk, just leave me a comment on LinkedIn, and I will try to have a look at that and pick it up while I talk. So diving in to the topics, the first one is a case from the Federal Patent Court, a judgment of that was on 9th of September, so it's a pretty recent one. That's an ownership assignment dispute about, well, two inventors. It was very clear that two inventors were participating in coming up with that invention, but only one of them filed the patent application in the name of a company, of her company, and the other inventor sued the patentee for assignment of this patent application or co-ownership. The technology that is at stake is a software, an artificial intelligence enhanced software that is meant to let's say discover incongruencies and congruencies between body language and the spoken word. So in essence, to determine the trustworthiness of what that person currently says. So I had joined actually the main hearing in that case, and I took from the main hearing that the expert opinion of the judge rapporteur must have been pretty unfavorable for the plaintiff. I took a note essentially saying that it was just, well, minor contributions of the plaintiff to what is actually claimed in the patent application. So I was under the impression that at least the judge rapporteur was tending to just dismiss the case. But apparently that was not the outcome in the judgment. The judgment says, well, it's not that easy. There is not just one relationship between the two inventors over the course of their whole collaboration on the topic, but there were actually three different relationships depending on the actual subject matter of the, let's call it, partial projects. And so now diving into the three aspects of their cooperation. The first aspect, the court held, it's a simple partnership. And really what but media and but really is, that doesn't matter for the outcome of the judgment actually. But in one aspect of their collaboration, it was a simple partnership. So it belonged to both of the inventors. But that was not relevant for the patent application that was at stake. Then in the second aspect of their collaboration, in that second aspect, the plaintiff was a contractor for certain other things. And these other things were also not found relevant for the actual subject matter at stake in the patent application. That means it was all about the third aspect. And again, in the third aspect, the court held, well, that the plaintiff was an independent contractor for that aspect, meaning profiling with artificial intelligence. And there were various indications that spoke in favor of plaintiff being an independent contractor for that aspect. Yeah, so that was all pretty much, well, at least from an outside perspective, I could follow that argument, and that appeared to make perfectly sense to me. Where I lost a bit track of the judgment was when it came to remuneration. Because an independent contractor should be paid. So there should be some kind of remuneration according to the law for that independent contractor for the work that has been done. It was beyond dispute that a certain number of hours was actually contributed by the plaintiff. But it was about, well, how was that to be refunded, remunerated by the defendant? And apparently there was a sort of agreement that a kind of profit share should be at least part of the remuneration for the plaintiff. The defendant essentially said, well, we only agreed on a 20% profit share for what is, well, what is the income with that software. That was the defendant's position, and the plaintiff, of course, wanted an hourly compensation for the hours spent on the project, and on top of that, a profit share. And yeah, that was pretty much the various positions, the one or the other or both of them. And then the judgment goes on and multiplies the 750 hours, I think it were, by an hourly rate of, I think it was 100 Swiss francs. And that was held a plausible hourly rate for the tasks at stake. And in the calculations of the remuneration, there was no mentioning anymore in the judgment about the profit share. So has the hourly rate been reduced in view of a profit share that was also due, which is not mentioned in the judgment, or has the profit share completely gone and it was only an hourly compensation, even though both sides obviously had agreed on a certain profit share at least? That was not very clear to me, and yeah, I can't tell more about that actually from the outside. What I can tell you is that the judgment has been appealed, so an appeal is currently pending at the Supreme Court. We shall see which aspects of the judgment are actually at stake in appeal. We will learn about that in half a year's time, roundabout. So that brings me to the next topic that I have on my agenda, which is the annual VESPA seminar on case law of the Federal Patent Court. That's a must-go event if you don't know it. It was due this year on Monday, by exception on a Monday. That was the 21st of October. And it was a hybrid meeting, so you could attend online and on site. And it was the most populated event that we had in more than 10 years on that topic. So it was, I think it was 80 attendees on site and 40 or 50 online. So it's really the must-go event if you are interested in case law of the Federal Patent Court. So that said, that seminar is always held under Chatham House rules. That means, if you don't know this rule, it means that you, of course, learn on the occasion of that event, that you cannot cite anyone for what he or she had said during that event, but you can, of course, discuss the subject matter that was discussed, and I will, of course, abide by that rule. So a hot topic, of course, was priority. As you all know, priority was being dealt with by the enlarged Board of Appeal of the EPO in G2 of 21. And there was a case at the Federal Patent Court that was Apixaban. That was a pharma case where we were involved. And while that case was pending, the enlarged Board of Appeal of the European Patent Office issued its decision on priority. And yeah, that of course caused some reshuffling in the arguments of the parties. That's pretty clear. There was one peculiarity in the proceedings at the Federal Patent Court, which were due to Swiss patent law, which is of course not the same as European patent law. The Swiss patent law explicitly holds in Article 20 that even though a priority claim might have accepted in pre-grant proceedings, the patentee has to actually prove the existence of the priority right in legal proceedings afterwards. So, as you will recall, the EPO said, the enlarged Board of Appeal said, there is a rebuttable presumption that the priority claim is lawfully, and that this rebuttable presumption is a strong one, but it is still a presumption. And here's the difference in the Swiss patent law that requires a patentee to prove the existence of the right to priority. So there is a difference in law, but does that really make a difference in substance and in particular in the outcome? So, and yeah, in a nutshell, at least in that case, it did not make much of a difference. So the enlarged Board of Appeal said, hey, you need to provide a priority document even before the application is published in order to validly claim a priority, and you can't do that without the cooperation of the applicant of the first application. So there is this strong presumption because you cannot have done it alone. There must be cooperation with the first filer. And that also had an influence in the assessment of the evidence, in the assessment of the facts that are in front of the court in Switzerland. So it did not really make much of a difference in the outcome of the proceedings before the Swiss Patent Court. So my take from all these discussions that we had, and also from the Apixaban decision is, well, it does not really make a difference under Swiss law, despite Article 20 in the assessment of evidence. And yeah, from the discussions, I believe that the whole topic of whether the priority claim is valid or not, at least in this aspect, if it's not the same applicant, that's a dead horse. You should not ride a dead horse, and maybe choose your battles wisely. So I think it will be hard to again come up with a compelling case where this really is promising to even bring that argument. But that's only my take from discussions and from the Apixaban case in Switzerland. Moving on to the next aspect that we discussed at the VESPA seminar, that was G2 of 21. That was about, the buzzword is plausibility, and the second headword of the enlarged Board of Appeal. I think the European Court of Justice could not have find a better wording in their discussions about SPCs. It's really a painfully complex headnote. You can rely on later filed evidence, but only if it is encompassed by the technical teaching and embodied by the same originally disclosed invention, whatever that means. And now, what it does mean is, of course, at stake in the follow-up decisions at the EPO. The enlarged Board of Appeal rendered a decision, and thereafter the referring board had to deal with that. And they did, and also another board did. And in their assessment, it was about a legitimate reason to doubt that must have existed if a patentee or an applicant should be prevented from filing later evidence for a certain effect. So that, in a way, sounds like ab initio implausibility, as it was called in the referring decision. When you look at the Apik Saban decision 2022-007 in consideration 38, that more reminds me of the ab initio plausibility test, but with a very low threshold. And very low threshold, maybe only in my understanding, because it should prevent an abuse of law. And since that is a rare case, so to say, the threshold for the ab initio plausibility test should not be too high. So there may be a difference in the assessment of the boards of appeal at the EPO in the aftermath of GE2 of 21 and the assessment of the Federal Patent Court. But yeah, we shall see how both lines of case law develop further. Maybe the difference is not that big in substance. That's just my first impression here. Another interesting aspect that we discussed is about ex parte preliminary injunctions, ex parte PIs, and how the chances to get an ex parte PI depend on the remaining term of the patent, ? So there was a recent decision in summary proceedings where the president, acting as single judge, denied an ex parte PI with explicit reference to the remaining term of the patent, and that it would be or should be acceptable for the plaintiff patentee to wait for the defendant to present his counter arguments in view of the roundabout 8 years of the remaining term of the patent. And on the other hand, there were two decisions, actually, two pharma cases where the patent was about to lapse and where generic manufacturers were already pushing on the market. And there, in one case, 3 months, and in the other case, 2 months of remaining term were held to be sufficient in order to grant an ex parte PI, because if the counterparty would be heard, meanwhile the patent would lapse. So yeah, that's just the facts. I had some discussions during the seminar with other people at the APRO, and I always wondered whether that is right, actually. Why is it more urgent the less patent term there is available? I think you could also put it exactly the other way around. Shortly before the lapse of the patent, you already enjoyed almost 20 years of the patent term. So why do 2 months actually matter? And why do they matter? Do they matter more than if you are interrupted with your exclusivity in the middle of the term? That you could also argue that this causes much more confusion on the market than at the end of the patent term. But yeah, that's just my 2 cents. That's at least how it's currently dealt with at the Federal Patent Court. At the end of the term, it's more likely to get an ex parte PI than if there is a large term still remaining. Then there was some discussion about bad faith. When are you, as a patent infringer, acting in bad faith? That discussion was triggered in view of the Coram case that was 2022-002. That's about the financial claims after the Federal Patent Court had found that Coram infringed the patent. And the subsequent proceedings were only about the disgorgement of profits from Coram. And of course, bad faith or good faith is decisive in that situation. And give you a quick reminder of what happened in that case. That was actually a combination of not just one dependent claim, but I think it was 4, 5, or 6 dependent claims combined with a former independent claim. And even in the dependent claims, certain ranges and preferred selections were reshuffled. So it was what was a quite complicated amendment that had been made to the claims, but it was all based on the claims as initially granted. And my take here, and that's what the decision also said, is if it's still a combination of claims, then then it's simply bad faith. You need to take care of all the claims that were granted, and you also need to expect combinations of claims, in brackets, be it as complicated as it may. And it might well be different if you pick features from description, I believe. Then it's maybe likely not anymore acting in bad faith. You don't need to anticipate that a certain feature is being picked later from the description and the patent is maintained only on that form. So what does it mean for prosecution? Maybe put everything in dependent claims that you might need later on when you need to limit your patent in inter partes infringement and nullity proceedings, because one might still help you to maintain the patent in a form that is still infringed in bad faith, and picking from the description, likely not anymore. So that was it, what I found the most interesting parts from the VESPA seminar. Moving on to a Swiss draft legislation that was recently sent out by the legislator to the interested circles for comments. I will quickly walk you through what had been presented. So there was a press release of the Federal Council in May 24, and there was proposed a revision of the Swiss Patent Act, and it was all about plants. And there was a proposal to establish a clearinghouse for plant patents in order to make breeders' life more easy, in a nutshell. So the time limit for comments ran until 12th of September 24, and a lot of comments, to my knowledge, were made. I will come back to that in a minute. Quickly walking you through the highlighted things here in the press release. The proposal was meant to make it quickly and easily available for breeders to check whether a certain variety is protected by a patent. And the gist there was, breeders start a breeding program, and a breeding program takes pretty long. They only can select the favorable crossings 1 year thereafter, and then they only see the results again 1 year later. So it might easily take 15, 20 years until they come up with a final resulting breed. But they wanted to know upfront, when they start their breeding program, whether any of their source varieties that they start with is actually protected by a patent, because they wanted to know whether they have a certain risks that they end up with a breed that is patent protected. That could, of course, easily happen when they start with a variety that is patent protected. And then in the last paragraph here on that slide are the reasons why that change to the patent law was deemed necessary. Breeders are taking efforts that take many years, and breeding is costly. That happens to other entrepreneurs too in any other commercial situation, I believe. And analysis of the patent literature is not that easy. It's challenging, as it's said here. Well, yeah, that's true for everyone. And then disadvantage in breeding environment is that it's more and more technical. Yeah, that's true for many other fields of technology too. And then in substance, as a subordinate heading here, the clearinghouse should help to make patent searches more easy. That's a bit very simple in my mind. So the press release here said it should act as a kind of intermediary between breeders and patentees. And the breeders could publish the varieties they want to start their breeding program with at the clearinghouse. And then the patentees could just submit their patents if they believe that any of these varieties the breeders want to use are patent protected. And that was meant to increase transparency. Transparency is, of course, nothing that anyone could object to. Transparency is good. So any criticism is really having a hard time based on that press release. And the last highlighting here says it's that the use of that clearinghouse is voluntary for the breeders, and it does not mention anything about the patentees. And that's where the trouble starts, actually, because the whole press release is silent about the disadvantages for the patentee, which are as follows. The draft legislation says that patentees have 90 days from notification, and the patent office will notify them. Not sure how they make sure that they catch everyone, but they say they will. So within 90 days, the patentees have to come up with their patents that might be at stake there. And if they fail to do so, then the breeder is free to use the resulting variety without any remuneration or license fee being due. The press release is silent about that. So it's not that voluntary for the patentee, at least, to take care of that clearinghouse, because otherwise, if they don't, or if they simply miss the 90 days time limit, they cannot use their patent right anymore against that breeder. That's not a really balanced intermediary, that clearinghouse, in my reading. So, to the best of my knowledge, all the interested circles that are interested in the law, VESPA, FIPS, VSP, AIPPI, LES, Economy Suisse, I think none of them was really in favor of that kind of unbalanced intermediary. But yeah, we need to see what comes out of this draft legislation. If you want to have a read at my personal contributions that I also filed within the deadline, it really summarizes my opinion. It's one of the worst pieces of draft legislation that I've ever seen in recent times, at least. And the most impressive thing about this motion is that it made it this far. It has to go away in my mind, but that's just my opinion, and we shall see how that plays out. So yeah, that is my blog post. I'm pretty sure you will find it on my blog, and I've hyperlinked my submission during consultation there. So moving on to the next one, that is not a patent court case, but it's still about a Swiss patent. That's the DABUS case that now also made it to Switzerland. So DABUS, a case that is about the Artificial Inventors project. The background there, if you have never heard about that, is DABUS is a machine, actually, a machine that had been trained with data, but not trained for a specific purpose. And that machine came up with various inventions, and one of these inventions is a food container. And there is a patent application pending for that food container, and that case had been tested in various jurisdictions. And the question always is, who is to be named as the inventor? The owner of the machine, Stephen Thaler, says, "Well, I just dumped data on that machine. I did not prompt it with any specific prompts to come up with an invention. So if there is any inventor, then it's a machine." And in most jurisdictions, that caused severe problems because the traditional view is that only humans can invent things, and that's codified in many laws, and that then causes troubles when the applicant says, "I didn't invent anything, my machine did it." So now moving on to the EPC, where or the EPO, where this application has of course also been tested. That was also being dealt with by the Judicial Board of Appeal of the EPO already. And one request of the applicant there was, hey, if your view under the EPC is that only humans can be named as inventor, then I cannot name a human being. But since the whole gist, the ratio legis of naming a human inventor, according to the travaux préparatoires of the EPC, was to protect the human inventor. If there is no human inventor, there is no one to protect, then I just cannot name anyone, and that should be fine. And the Judicial Board of Appeal had expressed sympathy for that argument, but that request at the EPO failed for reasons of the second sentence of Article 81, which is on the slide here. If you don't name an inventor and de facto the machine is the inventor, how would you prove how you got the right to the European patent from that machine? The machine will not sign an assignment from the machine to the applicant who owns the machine. So that actually was the reason why that request at the EPO failed. Now, the interesting part in my mind for the Swiss case is the following. We had a similar requirement in the old patent ordinance, Patentverordnung. I think it was until 2008. There was really a similar requirement that you have to provide a declaration how you obtained the right to the patent from the inventor. That was codified in Article 34. But that is gone since 2008. Article 34 of the patent ordinance nowadays does not say anything about that anymore. You just have to name the inventor. Now, applying the same reasoning that the Judicial Board of Appeal of the EPO had explicit sympathy with, if there is no human, you can't name one, and there is no need to name one because there's no human interest that should be protected, then you just name no one, make a bar or write none in the field where you need to designate the inventor, and all should be fine because you don't have to provide any indication how you obtained the right as the applicant, at least not a codified one. So that will be interesting how that will be decided in Switzerland. The hearing in that case happened on the 15th of October. That is only about 2 weeks ago. That this hearing was at the Federal Administrative Court, and that was a quite crowded hearing. Normally, the public is not really interested in patent cases, but I think there were 10 to 15 guests at that hearing, and Yeah. One interesting aspect there was that the court was really asking questions to the representatives of the patentee. Oh, I need to mention that our firm, together with Andrea Mondini from Times Attorneys, represented that case. And in the end, the court really wanted to know what had happened in coming up with the invention. And some questions were asked to the court, and we were set a 2 month time limit to respond to the questions of the court, going down to the details how that invention was made. And yeah, we were set a two weeks deadline, and we responded by now and clarified these questions of the court. We filed a declaration by Stephen Thaler, essentially also again confirming that he just dumped some material on that machine, no prompting whatsoever that guided the machine towards invention. But yeah, we shall see how the court deals with that. But the promising thing there was the court was really interested to understand what happened there, and yeah, we are looking forward to that decision. Now moving on to the next thing, that is again an EPO matter. That is a Board of Appeal decision concerning to the adaptation of the description that is more and more required by the EPO. I think patent practitioners will know what I talk about here. And the interesting thing here is that everybody was waiting for a referral to the enlarged Board of Appeal from that Board of Appeal here in that case, because more than a year ago, that board indicated, hey, we believe we need to refer a question to the enlarged Board of Appeal because there is diverging case law on that aspect. And they even discussed the wording of the questions to be referred to the enlarged Board of Appeal. And then the applicant there said, yeah, please refer, go ahead. And then nothing happened for more than a year. And third parties were asking, hey, what's going on? And most recently, even the applicant asked, hey, what's going on with my case? I'm paying annuities. Do you refer or not? And then the decision came out, and surprise, surprise, no referral to the enlarged Board of Appeal. And when you read the decision, it's in my reading, it's written in a way that tells me when they started writing the decision, they wanted to refer, but in the end, they felt, hey, it's so damn obvious that the others are wrong. It's so clear. We just issue a decision and hold that's different. And so here's the catchword of that decision. Article 84 and the respective rules do not provide any legal basis whatsoever to require an applicant to amend the description to conform with amended claims, period. And the decision is a booklet of about 90 pages, and I like it a lot. It's well thought through. It's really comprehensible, and that's one of those things that I did not understand for quite a while. Why we have all these troubles with adaptation of the description. I made a blog post quite a while ago, more than 2 years ago, on that topic, and I dig through the whole travaux préparatoires of the EPC, and yeah, if you want to have a look at all the things that are found there, in particular in comparison to the PCT, where the requirement is even more demanding. The PCT requires full support of the description, while Article 84 only requires support by the description. And in coming up with a wording of the EPC, it was the explicit intention of the legislator to come up with a less strict wording than in the PCT. And all the PCT member states do not have anything that is comparable to what the EPO demands in their national legislation. And they did not object to the wording fully supported in the PCT. So I fail to understand why the less strict wording under the EPC demands for more adaptation of the EPC, of the specification under the EPC than in any other country of the world. But yeah, maybe I am wrong. Maybe this T56 of 21 is wrong, but at least for the time being, we don't have a referral to the large Board of Appeal. So the legal uncertainty still remains, but this can't go on forever in my mind. And maybe it was even the intention to trigger a referral by the president, because just think of that. What now happens in the case that was decided in T56 of 21? The Board of Appeal instructed the examining division to grant the patent in clear contradiction to what the same examining division is instructed by the president in the guidelines. So if I was a president, I would be triggered to refer something to the enlarged Board of Appeal. But since if my instructions are different and I want to have that cleared up, and I believe that my instructions are the right one, I would have to refer that question to the enlarged Board of Appeal. So maybe it doesn't take so long until we see a referral to the enlarged Board of Appeal on that subject. Moving on to the next one, that is a quick catch up from what I already presented early on in the years. I will be very quick on that one. That is a decision from the Judicial Board of Appeal of the EPO that is now being reviewed by the enlarged Board of Appeal, because the applicant was not happy by that decision. And I can definitely understand why he was not happy. And it's all about the right to all proceedings. It's really a quick reminder of what happened there. And here are the catchwords of that decision. It's about a re-establishment of rights. And you, of course, have to state all your grounds upfront, and you can't supplement that at a later stage. That's pretty evident. That's not really noteworthy. But here is where the problem starts. The rights to a fair trial should undergo a dynamic interpretation. I always get nervous when I read about dynamic interpretation of the EPC. And here is what really concerns me. There is no absolute right to all proceedings at the EPO anymore. I don't think that's right, but that's what the Judicial Board of Appeal says here. And if the all proceedings do not serve any legitimate purpose anymore, then the requirement of legal certainty in due time not only does not require a board to summon for oral proceedings, but even prevents the board from appointing oral proceedings. That is a pretty hard one. And here are some citations from the decision. In that case, the decision oral proceedings would not serve any legitimate purpose anymore. They would not even make sense, the board holds here, because it's clearly inadmissible, the request for restitution, and therefore the request for oral proceedings is just obsolete. And the board issued a decision in writing, despite a request for oral proceedings on file. Now, what happened then? My concern was, as always, bad cases make bad law, and I had seen that at least one other board felt compelled after J6 of 22 issued to expand a bit on that, and they said here that parties have an absolute right to all proceedings, which is exactly the opposite of catchword 3 of J6 of 22. And that was backed by some older case law, luckily. And then they made a side note to J6 of 22, and they said, well, at least in the way we understand J6 of 22, that was, well, only in a very specific procedural circumstance, and in our understanding, that does not seem to relate to the central area of the European grant procedure, whatever the central area of European grant procedure is. Still, that is a bit worrying, more than a bit worrying, that the Judicial Board of Appeal does not believe anymore in the absolute right to all proceedings. I noticed early on in the year that there was a review procedure pending at the Enlarged Board of Appeal, and nothing was available in the docket at the EPO in that case. Interestingly, I requested access to the file and asked the Enlarged Board of Appeal to make the file public, as they normally do. It took more than 6 months until they finally did, despite, I think, 5 or 6 reminders. And now everything is on the file, so if you want to have a look at it, everything is public meanwhile. And the current state of affairs is now, and here's a quick reminder of how these review procedures are going on. It's first a panel of 3 looking whether the review request is clearly inadmissible or unallowable, and if it is, then they just dismiss it. If it is not clearly inadmissible or unallowable, then 5 members need to decide on that, and that's where we are currently staying here. We are now having a panel of 5 actually having a look at case. It was external members of the Enlarged Board of Appeal now looking at that issue. I think Mr. Deichfuss from Germany is at least an external member. So that really has a certain impact, and it's pretty much under the radar. And if it comes out badly, I'm really, really concerned if the Enlarged Board of Appeal in this review procedure would hold there is no absolute right to all proceedings anymore. But yeah, what can we do about that? So there is no referral to the Enlarged Board of Appeal where third parties could file amicus curiae briefs. It's really just a review procedure. And for the sake of completeness, that application has another problem because the annuity has not been paid, and it's still possible to pay the annuity till end of December this year. And if it's paid, we might see a decision from the Enlarged Board of Appeal. But if it's not paid, then it will lapse before the Enlarged Board of Appeal most likely renders a decision on that case, and then we have to live with the decision of the Judicial Board of Appeal in the isolated case there. But still, I'm not sure if it's an isolated case, and there is only one Judicial Board of the EPO, and that has definitely weight. So I would I would prefer if that would be clarified, but maybe it won't, because the annuity is not paid till the end of the year. So if you want to do something for the greater good, pay the annuity. Now the next part on the agenda is a quick outlook for public hearings at the Federal Patent Court. There are 2 actually that are currently upcoming. The one is already next week, which is actually a continuation of first part of the main hearing that already started in June last year. That's again an ownership assignment dispute with a conditional counterclaim for financial remuneration. Therefore, there are 2 case numbers. That will be on the 6th of November, and the other one that is coming up is 2023-007 on the 11th of November. That is rivaroxaban. That's a pharma case, and I think at least 50% of all bigger patent attorney firms are in a way involved in rivaroxaban. That will be a pretty crowded hearing. And from the announcement of the judgment of the hearing, and from my blog, you might already know that there was already a a dismissal of a PI request of buyer against another defendant. I think it was Helve Farm. So it's an uphill fight for buyer, but still, this is the first main hearing and main proceedings that's coming up here on the 11th of November. So yeah, that was pretty much it that I had on my agenda for today. Yeah, thanks for joining. I am a bit late today. Sorry for that, but I think it was hopefully worth it to stay a little longer. I hope you agree. Again, thanks for joining. If you have any comments, thoughts, whatever afterwards, please leave a comment on LinkedIn or drop me a line by email, and I will be happy to pick it up directly on LinkedIn or next time during the fireside chat, of course. And yeah, the next fireside chat will most likely be due on the last Wednesday of November, and I can then talk a bit about the two hearings that are here on the screen. And yeah, I'm pretty sure there will be an interesting decision to report in about a month's time. So stay tuned and have a good day, and bye bye. Thanks for joining.